Few things offer more excitement, more use, more power, and even more romance than ships traveling across the ocean or sailing down a stream. The value of powered transport across water to all nations cannot be overstated. No less important, though, is the power governing such transport. Welcome back to Law Dogs. I'm your host, Jeff Henley, and with me as always is Annabelle. Now today we're talking about big boat travel, the Constitution, and the Interstate Commerce Clause. In 1807, Robert Fulton invented the steamboat. When his Clermont chugged along the Hudson River, Fulton showed the world that people and cargoes could now travel upriver or across the ocean without wind. Like any self-seeking inventor with an opportunity, Fulton sought a monopoly. And good news for Fulton and his partner. New York State was willing to oblige. The Empire State gave Fulton and Livingston exclusive right to operate any boats operated by fire or steam within its jurisdiction. That is, the lakes, the rivers, and all of it belonged to Fulton and his partner if he so desired. Now, to ward off legal challenges, Fulton and his partner went about selling franchises so that they could continue to control shipping along the harbors surrounding New York, in the rivers, and every place else. Those licenses, those franchises, in essence gave Fulton and his partner a monopoly of all steam transit that was going to be taking place in and around the state of New York. And as you can imagine, competitors soon thereafter didn't like it. They wanted to prevent this big monopoly from restricting transportation going back from Jersey and New York and Pennsylvania and every place near there. One such partnership involved Thomas Gibbons of Georgia and Aaron Ogden of New Jersey. The partnership was going fine until Gibbons got a license from the federal government to operate in New York coastal waters. Aaron Ogden then sued his ex-partner to prevent him from operating his ship in the New York coastal waters. Now, in New York State Court, Aaron won. The New York courts handed Ogden a victory and granted him the injunction over Gibbons. Gibbons then appealed to the United States Supreme Court to overturn the injunction. Front and center of the fight was the Commerce Clause. Article 1, Section 8 states, Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Now, Thomas Gibbons, before the Supreme Court, was represented by Daniel Webster. Back in that time, Webster was quite the judicial stud, and he urged to the Supreme Court that the federal government had exclusive right to regulate interstate commerce. Ogden's lawyers, though, maintained that no, the states have a concurrent right to do so. Writing for a unanimous Supreme Court, John Marshall wrote that Daniel Webster's argument carried the day. The United States government would have exclusive right to regulate interstate commerce. The question would turn on two things largely: the meaning of commerce and the powers of Congress. Ogden asserted the definition of commerce should be limited to traffic, to buying and selling, or the interchange of commodities. Marshall rejected that premise. He said traffic is certainly a part of the definition of commerce, but commerce is so much more. He said commerce is intercourse. Now, when we think about intercourse, we think of something like this. But when Marshall is talking about intercourse, he means all the communication, everything that takes place associated with the interaction, the transportation, the deals that are made concerning anything in interstate commerce. Now, Marshall talks further about the Commerce Clause. He says, look, the Commerce Clause talks about Indian tribes. It talks about foreign nations. And it does so in the same place that it talks about among the several states. The importance of it is, they're saying is this. Look, you states think that you have the right to govern interstate commerce, but wait a second, we all know you're not going to be regulating commerce between foreign nations, or you're not going to be doing anything with the Indian tribes, but the federal government is definitely going to be doing that, and in the same context, we're going to give the federal government the power to regulate commerce among the several states. It's important, too, that when you're talking about among the several states, you're not saying we're regulating commerce from one border to another. We're talking about commerce being intermingled throughout the several states. That is, we're not saying the federal government can regulate the commerce at a border, at a boundary line, and only at a boundary line, but commerce that goes inside a state and across another state and into yet perhaps a third state. In interstate commerce, things just don't happen on the borders. Much of commerce flows through the states in their entirety. Agricultural products and raw materials in one state may travel to or through another. They may be used or then transported into finished products and transported still elsewhere. Commerce is like blood, which must circulate freely. So we established that Congress has the right to regulate interstate commerce. And Ogden really wasn't saying that it didn't. Ogden's trying to suggest, hey, it's concurrent. We get to do so too. But Daniel Webster and the Marshall Court agreed and said, look, the grant of the regulatory power is whole. It's not you get to regulate it and somebody else gets to regulate it too. It is complete. Because if it is only partial or if it's concurrent with the states, then guess what? You're not going to be able to regulate it. Now, Ogden and his lawyers maintain, sure, Congress has the right to regulate federal commerce. But guess what? The states do too. And here's what they maintained. They said, look, the states are sovereign. The states are the ones who created the Constitution. Daniel Webster and the Marshall Court said, nope, you're wrong. The states didn't create the Constitution. The people were the ones who created the Constitution. That is, the states were not sovereign creators of the Constitution. The people were the creators of the Constitution, and they are the ones who were sovereign. This is a debate that gets repeated throughout American history and frankly in the law, and it runs all the way up to the United States Civil War. And that is what is called the compact theory. And the compact theory is the states themselves are sovereign and in essence created an agreement, a partnership, if you will. Sometimes people would call it a league of states. And this theory, of course, has been rejected both by the Marshall Court and, frankly, lots of decisions ever since then. And, of course, it was fully settled during the Civil War. That is, there is no question today, and frankly, and certainly in Marshall's mind, that the federal government is not co-equal to the states. It is above, it is central, and it is absolutely supreme. Here's how Marshall explained it. We do not find in the history of the formation and adoption of the Constitution that any man speaks of a general concurrent power in the regulation of foreign and domestic trade as still residing in the states. The very object intended, more than any other, was to take away such power. What Marshall was talking about was the utter chaos that was taking place under the Articles of Confederation. The states were ripping each other off. New Jersey, which was sandwiched in between big bad New York and big bad Pennsylvania, for example, was getting smacked around. And the idea behind having interstate commerce regulated by a federal authority was, let's have a strong nation and not a series of states that may be beaten up on each other and far more easily to divide by the European powers that are far more well established. Now, the effects of Gibbons versus Ogden could not be understated. After Marshall handed down the victory for Gibbons, interstate commerce exploded. Gibbons versus Ogden has been credited with not only expanding steamboat travel, but helping launch railroads and telegraph lines, because inventors, entrepreneurs, and the companies that they worked for didn't have to worry that some state was going to jam things up as they moved westward or northward or southward. Some legal commentators have even compared Gibbons versus Ogden as the Emancipation Proclamation for American commerce. If you have any questions about this video or any other video on Law Dogs, you email us. Annabelle and I will see you later. Until then, you stay out of trouble or the Law Dogs will get you.